dialogue on comparative administrative law. I'm Isa American. I'm professor of law at the University of Essex. So for those of you who are not familiar with real law, and I see a number of familiar names in the chat, I will just say a few words on the journal before introducing the discussion today. So real law has four main activities. First and foremost, it is a journal which has been established in 2007 as a spin-off of a book entitled Europeanization of Public Law. It is now a Scopus and Fascia A-listed journal which seeks to advance scholarship on European and comparative administrative law, welcoming papers on any topics falling within the scope, especially on less known administrative systems than the usual suspect that we can have in mind. And it also welcomes paper using different methodological approaches. And for instance, we believe that interdisciplinary discussions have much to contribute to our legal field and its development today. Secondly, every second year, Real Law organizes a forum for young scholars with the best presentations selected for publication in the journal. The last such forum was held in Toledo in April 2022 on the topic of European administrative law and the challenges of uncertainty. 6 papers resulting from that forum have been published in our last issues this year, and we also published a call for the next forum to be held in Budapest on the 5th and 6th September 2024 on the topic of digitalization of public administration in Europe. And I believe the link will be available on the chat in 1 second. Thirdly, Real Law develops a blog to publish short pieces, usually roughly 2,000 word long, on relevant topics of European administrative and comparative law. So we organized recently series devoted to specific case law, such as the revisited Silfit case law, cooperation in tax matters, and Banco Popular. And the current series pertains to the very hot topic of beach concession case law, especially hot in Southern Europe. We also have series related to edited collections, such as on Article 47 of the Charter of Fundamental Rights, scientific expertise and the Habitat Directive, and indirect judicial review in administrative law. And if you are interested, let's stay tuned, because the next series will be on codification of administrative law. So if you want to contribute a piece, either for the journal or the blog, FIDs for case comment about these discussions or similar, please do come in touch either with the editors of the journal or myself. And I think my email will also come up in the chat. You are warmly also invited to follow our blog, and you can sign up to follow up our regular publications, or to follow our Twitter X account, and our LinkedIn account is also very skillfully administered by Danai with us today. Thank you, Danai. Firstly, and I come to what we are here today for, is that we started to organize online discussions around comparative law in Europe and related matters to try to foster friendly and supportive exchange and to broaden the conversation we often have in our field. The first discussion was held on the 3rd March 2023 on the role of comparative administrative law in shaping European administrative law, and we had guest star for that event, such as Professor Mendes and Sasha Prechal with us, and you can also listen to the recording, which is also available for that. So after this pretty long introduction, I can get to the reason we are here today, because we are gathered for the second of this cutting-edge discussion, and we are honored to have with us 3 distinguished colleagues to discuss our Tamir's papers entitled Empirical Administrative Law. So Oren is a postdoctoral fellow at Harvard Law School and adjunct professor and global house, a postdoctoral fellow at NYU. He will speak first for approximately 20 minutes on his paper, which is available on SSRN. And I think also the link for the paper will be put in the chat if you don't know it yet. Second, Professor Fischer will then join the conversation for approximately 10 minutes. Professor Fischer is professor of environmental law at Oxford and a fellow of Corpus Christi College. 27 book, Risk Regulation and Administrative Constitutionalism, has been tremendously influential in general and especially on my thinking about risk during my PhD research. Our most recent work with Sidney Shapiro, Administrative Competence, Reimagining Administrative Law, published with Cambridge University Press in 2020, was awarded the American Bar Association Administrative Law Section Scholarship Award 2021. So Professor Fischers is very well placed to have this discussion today with us. Thirdly, Professor Mariolina Eliantonio will have the hard task to follow on Professor Fischer's comment, and Mariolina is a professor of comparative and European administrative law at Maastricht University. She is the editor-in-chief of Real Law, the editor of so many books published by Oxford University Press, Bloomsbury, Edward Elgar, and Routledge that I lost count of, but they will be very well known to you all as the topics pertains to scientific evidence, soft law, judicial protection, environmental law, and standard, and I probably forgot a few of these topics. So with such distinguished speakers, the discussion promises to be fascinating. So I will leave the floor to Oren for 20 minutes and then for 10 minutes to each of the discussion. And then there will be a time for Oren to answer the question, and we will open the floor for a Q&A from the audience for the remaining time of today's session. So Oren, the floor is yours, and I think you have a PowerPoint to share with us. So I will leave it to you.
Great. Can you hear me okay? Perfect. Okay, great. Okay, so I'm going to try and share my screen. And of course, I'm going to start by saying thanks so much to Mariolina and Iseult for putting this together. I'm really honored, and it's such a great pleasure to kind of talk to this forum. When I was writing this paper, this is the kind of discussions that I was hoping to kind of really stimulate, and it's just tremendous that it's happening. And I also want to thank Professor Liz Fischer, whose work is really tremendous. When I was writing my dissertation, I was reading administrative constitutionalism and thinking about it. And more recently, the work that she has done is just, so relevant. And I keep going back to it as I think more about administrative law. So I'm looking forward to her comments, whether they're skeptical or critical. Everything is really kind of open. So what I'm going to do now is I'm going to talk to you a bit about my paper, and I'm going to try and give a kind of a bird's eye view survey of the paper, because I think there's a lot of things that are up for grabs to talk about, and that would be kind of worthwhile to talk about. So the paper is titled Our Parochial Administrative Law, and it's written for American audiences, but it's essentially for the purposes of this forum, it's about the title here that I've provided seems more apt. It's the parochial nature of U.S. administrative law and why it ought to stop being so parochial. So I want to start by saying Iseult sort of made a surveyed all the kinds of activities that are happening within the kind of European administrative law space that are comparative in nature. If you look at the comparative administrative law in America, it's basically non-existent. So Supreme Court of the United States doesn't cite comparative administrative law. The last reference, again, with one exception that I'll mention in a moment, is from 1936 in a case called Morgan 1, where the Supreme Court cited to the British House of Lords. Lower courts also don't cite comparative administrative law. The topic isn't mentioned in briefs. Even more broadly, administrative law scholars in America kind of are not aware of what's going on in other systems. They kind of, more focused on only the US. And the students in America, even though there's a lot of emphasis about administrative law and what is called legislation and regulation, which is a component in many US law schools that introduce students to the reality of an age of statutes and regulation, they learn only about the US, even though they're told in these contexts that the administrative state is important and also that we live in a more integrated world. So in America, we talk about we, us, our needs, both in general, but especially in administrative law. I want to note two exceptions that are important for that. So there are major scholars in America that do engage in comparative administrative law. So I note Susan Rose Ackerman, Peter Linseth, Francesca Bignami, Michael Asimo, and Bernard Schwartz, who passed away and taught at NYU. But I want to suggest that that exception is also quite limited. It didn't fully penetrate the core of US administrative law for several reasons. One of them is that some of these scholars are mostly interested in exporting US ideas elsewhere rather than bringing them home, in a way that they were talking to foreign audiences and trying to influence them rather than influencing domestic practice. Another reason is that some of this work is kind of historical and theoretical, very rich and interesting, not about judicial doctrine. And in a way, you know, it's a problem that I think not only in the US, but other countries as well, they're very focused on judicial doctrine. It's still kind of the core of of administrative laws, about the kind of how the law in the courts is operating. And finally, it's when you look at comparative administrative law, you look at how publications work in the US, the fancy important publications, kind of US general law reviews. But U.S. general law reviews weren't really interested in comparative administrative law. Most publication of comparative administrative law by these scholars is outside, either kind of specialty journals or kind of, you know, the handbooks or compilations. So in a way that, again, it didn't penetrate to the core. And another important exception is that recently, I said since 1936, it wasn't mentioned, but actually in 2022, in a very brief decision by the Supreme Court of the United States to deny grant of certiorari, which is kind of the preliminary stage to get a court to be heard by the full court and decided, there was a lengthy dissent by Justice Gorsuch, and the case was about whether the very famous Chevron deference should be overruled. And Justice Gorsuch, and I'll talk about the Chevron deference to people who don't know it in a minute, but Justice Gorsuch invoked comparative administrative law. He said essentially in one sentence that other systems declined to adopt a similar differential doctrine like Chevron. And Justice Gorsuch, of course, used it as a kind of a reason to undermine Chevron. And I'll get to that. So that's another exception, obviously, 2022 mentioning of comparative administrative law. But I want to suggest that's not a really good example. And again, I'll explain in a moment, but it's really a bad comparative law what Justice Gorsuch has done. It's shallow, acontextual, maybe selective, and even we could think abusive. Despite the exceptions, we live in a state of parochialism and or kind of one single example that's not really good. And the claim in the paper that this needs to change, this U.S. administrative law parochialism has to stop. And I want to say that I advance the argument in 5 steps. So I talk about history, what happened before the state of parochialism. I try and explain why we've become in America parochialism. I make a normative pitch for the revival of the comparative administrative law to take it seriously. I try to illustrate why it's important by focusing on various doctrinal domains. And finally, to the extent that I'm right and convincing that, you know, America should stop being so parochial, I imagine concrete paths for how to make this America less parochial in administrative law. So for the duration of this talk, I want to focus on some of the elements somewhat briefly. I'll penetrate to the illustrations more deeply, but I just want to give you a flavor of the kind of claims that to kind of lay out the argument so you'll have it. So the first step is history. So what I show in the paper is that maybe surprisingly for people like me who kind of, you know, relatively young and sort of like, you know, were educated in modern administrative law, it is surprising to see that the birth of the field of administrative law was actually deeply comparative, deeply transnational. So scholars like Goodnow, Freund, I'm just going to mention these names and not kind of go deeply into their work, were really keenly interested in comparison. It kind of made sense of administrative law through comparative references. And you remember I said that in one Supreme Court case in 1936, there was a citation to a British House of Lords case. That case was Arledge, which was a really important case both in the United Kingdom, but also proved quite influential to the way that administrative law adjudications in the US kind of operated. So it's kind of interesting to see, or surprising, as I say, that actually the field of administrative law is deeply comparative. So the second step is to try and explain. So why is, if we started from a point that it was a self-conscious exercise in comparative law and in administrative law, why is it now dead? And the dead, 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 by the way, is a slogan that Duncan Kennedy used to describe critical legal studies as dead, dead, dead. So comparative administrative law in America is dead, dead, dead. So why? The story is complicated. It has a lot to do with the need and what I call the indigenization of the US administrative law, especially after 1946, where we had the Administrative Procedure Act. It has to do with demographics. So a lot of the scholars and the judges who were interested in comparison had close ties to foreign jurisdictions, spoke other languages than English. So it made comparison much easier. In a way that's not easier today with the modern generation, with the demographics of the field today. It has a lot to do with the politics of administrative law. So again, very briefly, we know the Dicey story, at least in England. Dicey kind of had this very negative view about administrative law is impossible in common law jurisdictions. He said that in the UK, very influential also in the US. So the comparative law was a project to try and show that Dicey is wrong, to fend off the Dicey attack. Administrative law actually can work. And again, once administrative law sort of established itself, the politics wasn't as important. And finally, academic fads. So there's some evidence that comparison became less prominent through the 20th century and sort of was displaced by the more rational choice or public choice models, especially in political science departments. So this part is part of the story, but a big chunk of what I argue in my paper is that the field, there's a kind of an intra-public law asymmetry. The field of constitutional law, there's a strong sense of globalization and convergence among nations in a way that enabled the development of the field of comparative constitutional law. Administrative law hadn't experienced the same kind of globalization and convergence. Actually, the sense was that there's sticky differences that made comparison impossible. And so that's the step 2, trying to explain the story. And step 3 is kind of, okay, we had it in the past. Now it's dead, dead, dead. Now I want to call for the revival. So I argue that before I make the normative pitch for the revival, I argue that we can revive comparative administrative law, that we should revive it and explain how to revive it. So just briefly on each of these components, just to lay them out. So one claim that I make is that, as I said, we had the sense, or I argue that there was a sense where constitutional law was more converging and globalized and administrative law less so. I argue that this is no longer the case. There's much more cross-national administrative law fluidity. I'm not going to go into each of those. I'm just enumerating some of the dimensions in case we want to go back to these. So there's more cross-national administrative law fluidity. And there's also kind of an interesting trend of the globalization of administrative law. And just, it's very kind of familiar to this audience in the EU context and the Europeanization of administrative law. And obviously, I don't know as much as you about this, but I just want to briefly mention that there's also, beyond the EU, it's also evident, it seems like more and more international norms are not about the substantive regulatory standards, what we want in environmental fields or antitrust. They're also about concrete administrative processes in a way that affects and creates a kind of a gentle and sometimes more aggressive convergence between countries. So I argue that in the essence, the net result of this fluidity and globalization is that we either have, at a very thin sense, at least at what we think about as kind of a lingua franca, kind of a minimal vocabulary to kind of understand administrative law better cross-nationally, or more thickly, we can talk about there's a global sense in which modern states are doing a shared administrative law project. So if we think about constitutional law or constitutionalism as a project about constraining government or kind of enabling government and protecting rights, there's something about an administrative law project that all states are involved about, kind of on the one hand trying to discipline bureaucracies to preserve values that relate to democracy, rule of law, and rights, and on the other hand make these bureaucracies responsive, kind of make government work. So there's a global administrative law project that enables the comparison. I argue that, again, this is the can, I'm moving to the should. Why it's important? So if now we understand that we live in a world where there's more globalization, more fluidity of administrative law, then all the kind of benefits that we are familiar with of comparative law start to kick in. So genealogical, to kind of understand the origins of different rules, analytical, reflective, to just, understand one another through the comparison and contrasting systems, and institutional cultural reformists. So I'm assuming that pretty much everyone who's kind of thinking about comparative law is familiar with this. And I want to say that, so that's the general case, all the benefits of comparative law just apply to the administrative law. But today, there's also kind of, I argue, and maybe a more urgent need to kind of engage in comparison, because there's a sense in which, and I'm interested to hear more about this, but clearly in the US, there's a sense of crisis. There's a sense that administrative states are not doing sort of what we expect of them. The tension is more kind of crudely summarized, I think, on the dimension of one is a kind of a democratic critique of kind of a deep state in the administrative state, and the other is kind of a more effectivity critique that the administrative states are too bureaucratic in a kind of pejorative sense. They lack agility or innovation. So if that's right, if administrative states are kind of under crisis doing comparative law, all these benefits are extremely important or more emphasized today. And finally, about the how to revive, I defend an approach that I call, again, it's not, it's just a kind of a way to describe it, or kind of to give it a slogan, if you will. I talk about an approach that's modest and experimentalist, and in a nutshell, it's kind of the instinct is about reflection through comparative law, not necessarily or not immediately borrowing. It's a call about to be deeply contextual and careful when you make comparisons. It's a call to think about domestic justifications for different institutions and not kind of imagining or kind of relying too thickly on a highly globalized vision of administration. And finally, that any reform moves, any attempt at borrowing or tinkering to kind of through comparative law is through either what I call experimental, which essentially is about information percolation, just talking, trying to figure out whether the kind of cross-national, the other solution makes sense in domestic conditions. So that's kind of easy just to talk, to do, to be less parochial, start doing comparative seriously. And finally, if you want to take concrete steps, do it either in small steps in incremental way, or if not incrementally, if not in a Burkean sense, at least with a trial and error to kind of make sure that it works and kind of lean forward, but learn very rapidly. And if we need, then retract and go back and correct. Okay, so how am I in terms of time? Can I do a bit of the illustrations? Izul, Marielina, can we?
You have another 5 minutes.
5 minutes. So let's do some soft law, okay, before I leave it to that. And again, this is, I'm kind of laying out the stuff in the paper because I hope that we can pick out threads and kind of discuss and see if they make sense, or whether they make some sense only for the US or not. But I want to show the payoffs of the comparison. And what I do, again, the proof is in the pudding, right? It's not enough to just do another methodology paper, another theory paper. And what I do in the paper, I provide two puddings or two illustrations. One is the guidance and soft law domestication, and the other is Chevron deference. And what I think I'll have time to do is mostly to talk about guidance and soft law, and we can take Chevron deference, which I thought about systematically, and others I know are interested and thought about it as well, maybe in Q&A. So the guidance soft law. So just, very briefly, this audience is familiar with guidance. Guidance is kind of different from the two major policy-making tools in the administrative state. It's not adjudications because it's not case-by-case fleshing out of state regulatory standards. And it's also not what in America is called rulemaking. In other systems, kind of quasi-legislation or rules, quasi-legislation or delegated legislation. It's not general regulations that are binding. guidance is not case by case, it's also general, but it's also not regulation. So the key with guidance, the key with soft law is provisionality. It doesn't have the force of law. It's soft. Agencies or departments more tentative views, and it can be issued, changed, rescinded quickly. So it's different in a process that's different than the sometimes more cumbersome legislative or quasi-legislative process. And what I want to just suggest that guidance, again, or soft law is really kind of prevalent around the world. One US scholars describe it as oceanic, and the number of guidance dwarfs that of actual regulations or delegated legislation by a factor of 20, 40. And it comes in a variety of forms: manuals, dear colleague letters, circulars, etc. And again, the guidance or soft law is just a very general title. And we know that I'm gonna move over, but just very briefly, we know that there are advantages in guidance and there are risks. Some of the advantages is a kind of a tool for internal administrative law to control a lot of decision makers, kind of to give, not control necessarily, but give them guidance. And another kind of a value of guidance is to allow experimental governance. We can think about, we're not sure how to kind of regulate. We want to learn through trial and error again. So we go to guidance rather than kind of binding final regulations. But the risks from guidance, and again, it's familiar, that it will become, de facto regulation. It wouldn't be soft really, or it will have major errors. So it needs domestication. There's kind of presumptive case. And what I do in the paper, again, I'm going to do it very briefly to kind of just suggest some of the stuff. And the paper takes a more broader outlook, but I'm going to talk just briefly about just two systems, how they differently regulate or domesticate guidance. So very briefly, in America, there's a rule, or kind of the law now says that if a guidance is practically binding by its language, or if according to the agency behavior or industry, it's invalid. And another kind of element of the regime of guidance domestication is that there's no pre-enforcement review. So essentially, if someone isn't bringing a claim that it's practically binding guidance and hence invalid, courts wouldn't look at deficiencies in the guidance. And what I show in the paper, and hopefully I've captured it more or less accurately, again, the picture is more nuanced. In the UK, the situation is different. Practically binding guidance is not presumptively invalid, so long as there's a kind of an agencies leave room for exceptions. It's fine. Guidance in UK law, it's kind of fine. And also, the UK is more generous in its approach to pre-enforcement review. Important guidance are kind of exposed to pre-enforcement review for legality or arbitrariness of the guidance, and importantly, the kind of sensibility of the guidance, the bindingness of the guidance in context. So in some cases, UK courts might say, no, the guidance needs to be more binding because interest in accuracy or consistency are really important. In some cases, they might say, no, it actually needs to be kind of more loose because their interests are really important. There needs to be more individuation. So just briefly, the UK's domestication regime seems more permissive in principle than the US's, because binding is fine through guidance. It's more expensive because it allows pre-enforcement review, and it's more flexible. Courts police degree of bindingness rather than the kind of an on-off switch, the kind of binary solution in the US. And what we can learn, I don't have the time because I want to open things to discussion. But what I do in the paper is that I try and show two lessons of this through kind of putting the regimes one against another. One lesson is kind of reflective and analytical, to kind of go through dimensions of differences to try and explain. And again, I'm not going to linger on this, but we can think about all kinds of dimensions that help explain the differences that we see between the UK and the US. For example, the process, one of the features of the US is notice and comment, and the UK doesn't have a notice and comment, or there's an APA in America that has finality. So you can go through this. But what I argue, and again, we can talk about it later, but that it's important because through this, we can sort of understand, it helps us see better why we have the guidance domestication differences. But I also kind of push back against this very only reflective or kinesthetic or only analytical understanding, and also argue that maybe, and again, I'm moving to quite quickly, but I'm trying to get to another screen, that maybe the differences are kind of less clear in practice, that the kind of globalization of administrative law is maybe more apparent here in a way that might push even America or even the US administrative law system in the direction, again, modestly and experimentally, of the English, the UK regime. And again, I did it really briefly and without the richness of this, but we can talk about it more if people want to get into this. But this is just one illustration of why I think it's really valuable to stop being parochial in America and maybe hopefully more broadly.
Thank you very much, Oren. That was super rich as a presentation and an explanation of your paper. I will give the floor to Professor Fisher, if it's all right, Professor Fisher.
Yeah, thank you very much. And thank you very much for having me to talk. So, Oren, I really applaud you for opening up this conversation. And the problem is opening up conversations which people haven't been having for a long time. There will always be people saying, but what about this? But what about that? And I'm going to put 3 provocations on the table, but not to say I think it's really exciting what you're doing. And in actual fact, the provocations I'm going to put on the table, I think, are heading in the direction that you're heading. They're just asking us to think about what that matters. And overall, you said comparative law allows us to see better. I would go further and say it allows us to imagine better. And I will come back to that at the end. So my 3 provocations are this. First of all, what do you mean by comparative method? This is a point we have had email correspondence about. The second is to think about the expertise needed in administrative law and how that relates to comparative method. And thirdly, I want to make an argument for the values of parochialism. That's a really provocative kind of argument. Okay, so in your paper, you never actually define what comparative method is. What you do, and you did it in your presentation, is to point to what it definitely isn't, which is Justice Gorsuch in Buffington. And I think we can agree that definitely is not good comparative method. He says, and I'll read out what he actually wrote because I think it's useful. And courts in other countries that often consult American administrative law practices have declined to adopt the doctrine. He then cites an article, and then in brackets, he says, under British law, an error of law is generally subject to judicial review de novo. And as Oren has already pointed out, this is very shallow analysis, and there's 2 kind of problems with this. The idea of declining. There is really only one example in the Australian High Court where we can see that the Australian High Court, it was kind of put in as an argument and they just said, well, it's not our law. There's a kind of assumption in what Gorsuch is saying is that these other systems should be accepting it, which I kind of is amusing. The second is, of course, the use of language. This idea of de novo is not really one we use in the UK. We often use the distinction between review for error of law and a merits appeal. And so in a sense, this language has no kind of meaning. So what is comparative method? Well, in a piece I did a couple of years ago, I made an argument that there are 2 types we're often thinking about in comparative law, and this can be affected by functionalism, legal culture, etc., those different methods. The first is the kind of thin method, and that is in a sense where you are looking for patterns in different areas which are common, really by looking at the text. Now, thin is not a criticism. Thin is really important because you can often see patterns which you can't see if you're trying to dive deep into a legal system. And what I would suggest is that I think a lot of the really fantastic comparative administrative law scholarship that has come out of the US, I'm thinking here of Susan Rose Ackerman, I'm thinking of Peter Linseff's work, is actually of the thin type and influenced by political science methodology. But as Oren quite rightly pointed out, it doesn't really get into doctrine. And that's because, in a way, to get into the doctrine, you have to engage in a thick legal analysis. It's not just a case of looking at the doctrines in depth, in kind of context. You have to understand how it relates to other doctrines. We just saw an illustration of that in how Oren was thinking about the policy doctrines. And so there is a lot underneath the legal surface that you need to engage in. And that is incredibly difficult because not only is each administrative law system in each jurisdiction complex, they're also incredibly pluralistic within that process. So there's a whole debate within UK Commonwealth law about whether you can even talk about general principles of administrative law. Okay, so that's my first point. Second point, expertise. So why, Oren talked about why and should American administrative lawyers do comparative law scholarship. I, like many people in the audience who in Europe, do comparative administrative law scholarship. And so let me just tell a little bit about my personal history to explain why I do that. So as the accent suggests, I was educated in Australia. In Australia, as Peter Kane has pointed out, our legal system is heavily influenced by both the US and the UK. I went from Australia to Oxford to do my doctorate, which I wrote on American administrative law. I then took up a job teaching EU law and English public law. I still write on Australian law. I still write on American law. I still do some work on EU law. Why do I do that besides the fact that I'm a nerd? I do that because all those things are fostering my expertise. Administrative law is really, really difficult. We are dealing with a whole range of different legal ideas mixed in together, constantly dynamic. And I found the value of doing comparative analysis is not for finding some answer. It's actually understanding what administrative law is about. I find actually comparative analysis is pretty kind of limited. But what it allows is a kind of deeper understanding of what is at stake, what is at tension within thinking about administrative law systems. And we could think of that expertise having two aspects. One is a kind of explicit sort, which is just learning about the rules of other places. What's the Chevron doctrine? How do the UK approach statutory interpretation? You know, what do they do in Australia? But I think more importantly, there is what is tacit expertise. This idea is, you know, a kind of expertise of working with material that you only get from working with the material. And a kind of deeper understanding. And of course, coming back to Gorsuch, I mean, not only is he not doing comparative method, but there's not much tacit expertise in there. There is just kind of pulling an idea from a kind of another place. Okay, so that's my second point, that another reason why one would do comparative analysis is to foster expertise. My third is to make an argument for parochialism. And I realized over the weekend that just before Oren sent me a paper, I actually had prepared a paper for a conference in Sydney, which was called In Praise of Legal Parochialism. And that paper was about why I read, not only do I read the administrative law of other systems, I tend to read a lot of first instance decisions. And in the paper, drawing on the work of the American essayist Wendell Berry, I drew a distinction between provincialism and parochialism. So let me kind of quote from that paper. So parochialism is different from provincialism. Berry discusses the Irish poet Patrick Kavanagh on this point. Kavanagh states, "The provincial has no mind of his own. He does not trust what his eyes see until he has heard about it from the metropolis, what the metropolis has to say. In contrast, the parochial, Berry argues, is always assured of the imaginative sufficiency of the parish, the local place." Coming back to Gorsuch, he's being neither parochial nor provincial. By that, I mean, he's not actually that interested in the imaginative sufficiency of American administrative law. He's really making an argument about what is going on in other places, simply to bolster his own view. But likewise, he's not actually being provincial because his assumption is they are the metropolis. But With that said, I do think administrative law scholarship suffers from a sense that it is very provincial when it's compared to its big sister of constitutional law, which does seem incredibly kind of global and incredibly universal principles. And in a sense, administrative law, to use Barry's term again, is highly particularizing work. It's work where actually we really do care about legal place and care about legal meaning. And that brings me back to the 2 points I said before. What is comparative method? It is taking those deep dives into other places. And it's about building expertise. It is particularizing work. I don't think there's much that you can drag from one system to the other, but you can be better at what you do. So I want to actually end with a longish quote from someone who was the Chief Justice of the Australian High Court, Robert French. And a couple of years ago at a conference on public law, where kind of the issue of comparative method came up, he gave a speech. And this is what he concluded his speech with. Interjurisdictional dialogue is of great value generally and in the field of public law. Its practical effects are constrained by global legal pluralism. I return to the metaphor of a quilt of legalities. It took me through a Google search to an international movement called Modern Quilting and an international organisation called the Modern Quilt Guild, which has about 170 member bodies with, and this is his words, an eerie relevance to our present topic. It sets out the objectives of modern quilting, which are functional rather than decorative, interactive rather than repetitious, embracing simplicity and minimalism, and most importantly, focusing on finishing quilts on a home sewing machine. And then he concludes, good quilting and good public law have a great deal in common. Now, as a modern quilter, I like this quote, so I'm going to end with a quilt. And what I would say, and this comes back to kind of parochialism, is actually, not only is quilting finishing on a home sewing machine, it's also hard work, but then so is public law, administrative law adjudication. Thank you.
Thank you very much for this very clear comment, I think, and very provocative comments. I will pass the floor to Marjolina, and then we will listen to what Oren has to answer to this comment. Thank you very much, Professor Fischer. Marjolina.
Thank you. Thank you very much, Ezulte. And Oren, thank you for your paper. Congratulations for this paper, which is, in my view, really, truly a gold mine. And I dare say, for both administrative lawyers on this or the other side of the Atlantic. So I really, truly hope that it will become the first step towards more transatlantic comparative administrative law dialogue. So in that sense, I truly echo Lee's compliments that, as first steps need to be courageous. And I think you really managed to take that first step. And in my view, the paper is valuable for three reasons. First, because Oren proves quite well that despite what one might think, especially in the US, as we have understood, but I think there may be similar views also in Europe, comparative administrative law is both necessary and useful. However, second point, why the paper is valuable, this is only so, comparative administrative law is both necessary and useful only when the comparative exercise is done correctly. And Oren also brings forward some suggestions on how to carry out this task properly. Now, I'm very glad that I'm going to comment on your paper right after Professor Fischer's thought-provoking remarks, because in fact, without any coordination, actually, several of the points that I will make will build further on those that have been made. And indeed, both Oren and Liz caution against certain risks of misusing or even abusing comparative law. So in this intervention, in these comments that I have, I would like to go a bit deeper into the risks of doing a comparative law. And again, that's not at all to detract from, the very brave initiation of this comparative exercise for US scholarship, but also, again, to engage in a further dialogue on how to mitigate those risks, which are typical of very many comparative law endeavors. At the same time, not to finish with a negative note, I will also try to propose some avenues on how to mitigate these risks, let's say. So I will come in a moment to 4 dangers of trying to do comparative administrative law, which I think we should all be mindful of. I think that in all of those in the audience that have been doing comparative administrative law research have hit one or more of such roadblocks in the past. And I will call them the danger of the unknown, the danger of the unwritten, the danger of the unsaid, and the danger of the unspoken. Now, I'm aware it sounds all a little bit like a Harry Potter novel, but the reality is a bit, perhaps slightly less glamorous. So first, the danger of the unknown. If one doesn't know precisely what one is looking for, one will have a certain hard time finding it. For example, an English lawyer will never go and search for the conceptualization of factual action in Germany because this is a non-issue in English law. At the same time, a German lawyer will be astonished that there is no discussion of what qualifies as the equivalent of a real act in English law. And as an astonished German colleague said to an English colleague during a comparative law discussion, he said, "But you surely have police cars driving around in England now, don't you? So how do you qualify this administrative action?" Now, the puzzled face of the English lawyer spoke volumes about the perils of comparative administrative law. So beware of what is not there, because it might be as important for comparative investigation as what is actually there. So the danger of the unknown. Second danger, the danger of the unwritten. Now, there is more, in my view, and I think Liz was hinting at that, there's more to understanding a legal system than law in the book, be it legislation or case law. And this is more the case in some legal systems than in others. Now, in my own PhD research, I had to investigate, amongst others, the ex officio powers of a number of national administrative law systems and the extent to which these powers were exercised in respect of EU law rules. I simply could not find any of such rules when it came to judicial review in England. So when eventually I went on my study trip, let's say, in England, and I asked a barrister, he replied, "Of course, it's possible for courts to raise point of their own motions as a matter of fairness. And this, of course, ought to apply also to EU law matters." So when I asked, well, where can I find this in the CPR? He replied, "It's a matter of fairness." So this time it was me, the hardcore codification person, pulling the puzzle face. So beware of what is not written, because it might be as important as what is written. So the danger of the unknown, the danger of the unwritten, the danger of the unsaid. And I think Liz was referring to this as the thin and thick kind of comparative method. And as we all know, there is more to many doctrines of administrative law that meets the eye. Wensbury unreasonableness or the principle of proportionality may mean in concrete terms very different things in each specific case that is being adjudicated upon. When the administrative action is eventually deemed unreasonable or disproportionate may vary if one examines the facts of the case, the reasoning of the court. However, when we do comparative administrative law, we tend to rely very often on general principles, doctrines, without looking at the nitty-gritty of the daily application of the principles. And in a recent book I co-edited on the application of the Habitats Directive in several member states, I realized, for example, that the idea that I had of how German courts use the principle of proportionality, you know, this mythological 3 steps of the proportionality principle, creating a very intense control of administrative discretion, what I have been teaching to my students, is in fact rather distant from the reality when it comes to complex scientific assessment in situations of uncertainty. So again, beware of what is perhaps too easily said and look for the unsaid. So the danger of the unknown, the danger of the unwritten, the danger of the unsaid, and this brings me to my last danger, which is the danger of the unspoken. Why? Because it is difficult, in my view, to do in-depth comparative administrative law research and you know, to avoid the danger of the unsaid, especially look at the legislation, look at the case law without speaking the languages of the legal system one wants to investigate, because then we are limited to secondary sources, which in themselves may be limited. So is there any way to overcome these dangers? Oren mentions this in passing in his paper, but I think it is worth stressing this even further. I think we need to take a firm collaborative turn in comparative administrative law research. No such comparative administrative law endeavor can be meaningfully undertaken by one single scholar. It is time, in my view, to team up, create networks, communities of scholars who engage in comparative administrative law research. And these dialogues, such as today, are meant to create this community, which in my view, and this also echoes the US perspective, which Oren has offered, have been way too disenfranchised till now. So once more, Oren, thank you very much. Congratulations on this brilliant paper. And thank you for starting what I hope will be a long transatlantic dialogue. Thank you.
Thank you very much, Mariolina, for your comments. So, Oren, do you want to answer Professor Fischer's and Mariolina's comment, please?
Yes. Okay, so I'll do it. So thank you so much. Terrific comments. And, you know, it's really kind of the paper is a kind of a placeholder to start having the conversations, and, you know, a go-to place where we can sort of go to some of the basics and see some of the exercises. So I'm really hopeful that it continues. So let me refer to 4 points. One about the methodology that comes both in Professor Fischer and Professor Antonio's comments, and then I'll talk about expertise as a reason for comparison that Professor Fischer talked about in the nice provincialism versus parochialism, and finally about collaboration. So on methodology, so I'll tell you a secret. That secret is about what I was most dreading about the paper. So we said that the paper is kind of a, you know, initiate a conversation, but here's something that, you know, the paper is really long. It's so long that it's, you know, in European standards, it might have been split to 4 papers at least. In American standards, it's quite long, even in American standards. And as I was writing this, precisely because I think I was aware of the kind of thin, thick distinctions, again, implicitly, and the unknown, unsaid, unwritten, and unspoken. Unknown, yeah, I found. So it takes a lot of time to do the kind of work, especially as you go to the doctrine, as I do the policy doctrines or the kind of guidance doctrines. Takes a lot of time to go through them, and even then I'm worried that I'm missing a lot of texture. So what I want to say is that my dread about the paper is that it has a kind of a self-defeating quality. On the one hand, it sort of calls for the revival in the US of comparative administrative law, but it's so long and intricate and qualified that it shows in the process that it's really, really hard to do. So that's kind of the concern. But of course, the response is, okay, so that's the initial paper. and we're going to do it, collectively and collaboratively, which I'll talk about. So I just want to emphasize that I'm very much aware. So even though I don't define what is comparative methodology and don't address the entire risks that you've highlighted, I'm very much calling for the kind of thin, thick engagement with doctrine that's aware of the risks. So even though I don't explicitly define them. So that's on methodology. What I wanted to say about expertise, I totally agree about as a kind of comparative law is kind of to improve the expertise. And we didn't get a chance to talk about it, but I think the Chevron example is really kind of illuminating for that. On the one hand, so when you look at the deference doctrines comparatively, so the idea that one might take from jurisdictions like Canada and the US is that, well, it matters whether there's a presumption of deference because it matters perhaps who kind of has initial ownership on the interpretation of law, whether it's kind of courts or agencies or departments. So that's kind of something that you learn through engaging with deference doctrines, even though you're not necessarily kind of exporting this. So the deference idea seems important in terms of who has the kind of initial ownership. So that's one thing that jurisdictions that don't have deference can learn. But on the other hand, for me, I mean, the move that I'm making in the paper is that the idea that deference hinges on ambiguity or vagueness, that it's kind of a formalized exercise is also kind of unclear. That maybe if we look at different systems, we see that interpretation is a more constructive, to use, by the way, Liz's term that come from the UK. So that's exactly why you do this. It kind of opens different avenues to understand what interpretation really entails for all people involved. So definitely it's about expertise, which brings me to the provincial parochial. And again, my defense because I also accept the kind of risks and the need for thick comparative analysis, I'm also against provincial, but more parochial. And I just want to go back to use your terms, Liz, even though I call for less parochialism. But again, the slogan that I give, I think, is meaningful. It's not like a good acronym, but it's like modesty and experimentalism. And what I want to see again, what I'm calling is that you start with a position of caution, contextualism, not borrowing. You learn, you reflect, you get expertise from comparison. That's the initial thing. That's mostly what you do through comparison. But I think, and this is maybe slightly pushing back against some of the things that you said, Liz, I do think that we can engage in some expertation. Again, I don't call it's not expertation or borrowing. Again, it kind of raises all the comparative law methodologies that we know in the field, but to try and move slightly the needle in the directions of, trying stuff that we see abroad, imagine our cultures differently. Again, from modesty and experimentalism, I think we can allow ourselves to do so. And I do call for this in the paper. So in that sense, I am kind of even accepting and a more schizophrenic about the parochialism label. And finally, I'll just say, collaboration, Mariolina, that's definitely the way to go. Again, I have a very ambitious call at the end of the paper. I say that all American administrative law scholars should have a side project with a collaborator from a different jurisdiction. And again, that seems like, again, it gives a kind of a concrete institutional suggestion to how to bring it about. But I do think that that's the path to do so, and people should do it more. And hopefully we are starting the conversations that will enable this.
Thank you so much for your answer and your constructive answer, I think. Oren, I don't know if Mariolina or Liz, you want just to briefly react, or if we can open the floor to broader discussions?
I'm happy. I mean, I've got 2 comments, but it would be fantastic to hear from others.
Okay, that's great. So I would like to ask if there are some comments from the audience, if people can just... if not, if people are still thinking a little bit, I will maybe abuse of my position, because I have maybe two points or 2 questions for you, Oren. One is, what about internal comparison within the the US. How much do you factor that possibly? I mean, I'm not at all familiar to that side of things, but I would be interested in hearing a little bit more of that, because it's not just the Supreme Court. There are also lots of things at the local level, and what happens there. And my second point would be, and I think you are a little bit alluding, or at least your two examples shows that you might be aware of that, but I would like maybe to hear a little bit of your thoughts, because administrative law can be judicial review of administrative action, but that's a reactive way to understand administrative law. It can also be far more positive in a way, in the sense of how you organize the administration. It's much more leaning towards public administration, maybe in the US, but in continental Europe, it would be the core of administrative law. And I wonder if there might not be a way also to have a broader discussion, and if the methods that you are trying to highlight and to flag might not need to be seen differently, or different strategies. Of course, collaboration is also always good, that I'm sure of. But once you go a step further, do you see a difference between the two approaches, the two sides of administrative law? And then I promise everybody can have also their words or comments.
So yeah, perfect. Great question. So just briefly on so one way I argue for, the US to start looking abroad, but there could be a different argument, look more inside, not on the federal level, but state and local level. So two responses to that is that's already happening. Again, not intensely. There's a kind of a similar article to mine that says our parochial administrative law, that's at the Yale Law Journal from a few years, probably almost 10 years ago, that's called Our Localist Administrative Law, or like that makes the argument that federal administrative law would benefit from thinking about local and state government. I want to say so, and they're not mutually exclusive, right? They should do both. But one thing that I think at this moment, or one way to put this, I think that the marginal benefit for the US to do more comparative outside, abroad looking, is higher than the marginal benefit of state and local. There are various reasons, but I'll give just one. At least for the state level, politics at the state level in America tend to replicate or kind of second order and hinge on the federal level. So for example, some states don't have Chevron. Some states in the United States, they don't have deference. But the reasons wouldn't be that different from the reasons where we see the attack, the Gorsuch-esque attack on Chevron on the federal level. They would just dovetail those because, again, it's a complicated story, but the conservative movement is just more successful at the state level, and this is why it happened. If we look abroad for other countries, why they don't have these similar deference doctrines, we get much more illumination, much more imagination for different solutions. So that's about why I think we should do more international, and about the kind of beyond the core of the doctrines to do more institutional. You're very right. So the reasons that I focus on the policy doctrines or the guidance and Chevron is just because they're so prominent and important, and I want to get people's attention to doing like kind of core US ad law doctrine and comparison. But of course, we should do it also for institutional arrangements. So one example that I think would be really interesting, think about administrative law adjudication, what happens at the agency level, how they adjudicate disputes, like the giving benefits at the Social Security. There's so much cross-national variance. So the US model, Michael Asimo is one scholar who has written a lot about this. The US is very a disaggregated model that each agency has a kind of a unique structure. Other systems have a system of tribunals that has more independence. I'm very much so to think, creatively. I don't know if under current doctrine in the US it might be complicated, but I want to invite people. But final thing that I'll say about that, you might be right that the modesty and experimentalism method for these sorts of institutional changes could be adapted or might need adaptation, just because it's not easy to experiment with these kinds of, how do you structure adjudication in an agency? You can't do necessarily, or it's not obvious how you do trial and error with them, or how do you do like incremental steps. With doctrine, I think it's somewhat more kind of intuitive.
Thank you so much. That's very interesting. So yes, if colleagues have some comments for Orent or want to.
Isolt, there is a question in the chat.
Sorry, I did not see that. So Emma Lucia, do you want to say it, Emma Lucia? If you want to explain your question.
She says she cannot speak at the moment.
Okay, so I will read it for you. Thank you very much. I'm sorry. Do you think that the comparative approach is the most suited way to tackle parochialism? If so, why? I'm thinking, for example, about the interlegal approach as a possible alternative. So she's mentioning or thinking about Professor Klabas and Professor Palombella in that respect. So do you have something to say about that, Oren?
I don't know enough about it. I'd be curious to hear about the interlegal approach. I don't think that I know enough, and it sounds fascinating. But my reaction is that I guess I imagine that the only way to rid ourselves of kind of the negative side of parochialism, I should now say, with after Liz's comments and modifications for the term, is to start, looking at what other countries are doing. Just, get it into our system and gain the expertise that we get from that. I'm interested in understanding what the interlegal method is, how the interlegal method is different.
Can I come in here? And I don't know the interlegal method, but I think exploring other legal systems is really valuable, exploring lots of different methods is really valuable. But I just wanted to kind of build on that comment and also what Oren said. I mean, I think one thing that is running through your paper is an assumption about reform. Well, I actually think comparative, looking at other systems is actually just about doing your job really well. So it's not actually about trying to change anything. It's just understanding what is going on.
Right, but so one other frame that I could suggest is that I don't want to reform Chevron or guidance. I want us to do the comparative exercise, and then through that we do our better job and start, rethinking our own institutions in light of that practice. So the understanding can breed reform, even if it's not borrowing.
Yeah. So then it comes I would push back against your depiction of the states, because actually, if doing comparative work has taught me anything, is to dig deeper into our assumptions about what goes on into different legal systems. And also in the chat, they asked about the paper. Wendell Berry's essays you can find in his collected essays on this. But I can circulate. It was a conference paper, so it will have typos in it. But that was, as I said, a paper about why I read first instance decisions. So, my work is not, the more I do it, the more I get down and realize that often the way we depict the local is very misleading, and there is so much going on in there. And of course, the other thing about comparing these systems is that the US, we are really looking at federal administrative law. Right. In the UK, you are looking at administrative law that also applies to local authorities. And everything that Marilena said, I agree completely. And that just creates a different kind of dynamic. The 2 points I wanted to make is one about time, and this comes to the reformist point. To me, doing comparative work takes a huge amount of time because you're trying to get your head around the unsaid, the unspoken, the unwritten. And there was another, it was fantastic. I put it down here. And the unspoken, the unsaid, the unwritten, and the unknown. And that takes a huge amount of time, even in collaborative sort of settings. And that doesn't always sit easily with the tempo of academic life, where the result is meant to be here. I find this kind of work takes years. And that relates to my point about imagination. We're always using our imaginations. They're the mental constructs we use. And in a way, coming back to the point of expertise, part of it is, I don't think deference is a very useful word. Everyone always rolls their eyes when I say that. I don't think, I've frozen. Can you see? Are you hearing? Yeah.
We can hear you.
Yeah, okay. I think what is law means something fundamentally different in different legal cultures, or at least how scholars think law is. So I mean, I think there is a lot. I will just see if my video is, yeah, that we're back. So I guess what I'm saying is I think it is really valuable, but it's not necessarily the most efficient way to get there. And I will see if I can upload this conference paper, which is just to be circulated to people in this group, but if that would be useful for people.
Thank you. Yeah, thank you. Yeah, Oren, do you want to answer?
No, yeah, I wanted to, so again, when you read comparative law, again, and I think I say this in the paper, you kind of see there are kind of two extremes, right? The people who are kind of universalists who believe that everything is essentially the same. We can borrow and kind of do, comparative law is kind of a key tool. And there are the skeptics or kind of, believe that everything is different. And my intention I'm not on any of these extremes, and I don't think that any of us is on the extreme. I am closer to the skeptics in the way that I want to caution against kind of, immediate borrowing, immediate kind of transplantations. But I do want to open the door slightly toward that. And what I wanted to say is that I thought would be kind of interesting and thought-provoking, and I'd be interested to hearing your thoughts, is that, and I think that you'd agree, I mean, Liz talked a bit about constitutional law, the process of convergence and globalization that occurred in constitutional law. Administrative law, even though I make the argument in the paper that has kind of moved in the direction, we can't say that it's completely divergent world, is still kind of has the thick comparison is still hard because there's so many variables. So what I want to suggest is that maybe in administrative law, we should even especially be closer to kind of the skeptic side of the polls when we do it. But again, I don't close the door on moving ahead in directions that lean on direct inspiration from comparative laws.
Thank you. Mariolina, do you want to add something or comment? Or
If I don't know if there are comments from questions from the audience.
If not, I have another little one, if I may, for you.
I also do have one.
Sorry, go ahead, Mariolina.
Well, one point that that seemed clear to me in your paper, Oren, is that you at least at this stage of development of comparative administrative law in the US, you see this still very much as a scholarly exercise. So it should be scholars who engage in comparative administrative law, but I guess that eventually you want judges or legislators to read those papers.
Right.
So I wonder, where you see courts and policymakers in this comparative law exercise.
Right. Okay, so I do see them, but I don't see them. I don't want them, obviously, to Gorsuch repeat, right? So the conditions need to be ripe, or then there needs to be a broader change in the ecosystem of the U.S. interest in comparative administrative law that would enable eventually responsible citing in briefs, responsible judicial learning provocations through comparative law, again, in the kind of modest and experimentalist frame that I'm imagining. But so I'm calling for a kind of a general ecosystem change that would bring about a revival of comparative administrative law as a meaningful practice or consistent practice. But I hope that some will start making the moves seriously, even without the ecosystem, that it will kind of build itself slowly and gradually. And I don't think, again, I just came back a month ago from a conference in the University of Toronto for the third edition of the Comparative Administrative Law Handbook of the Edward Elgar one. that Susan Rose Ackerman and Peter Linseth initially edited, and now there's a really exciting new group of editors. And there was a paper about comparative law units in the Conseil d'Etat, about the capacity of the Conseil d'Etat to engage in comparative law through those institutions. So I wasn't imagining these sorts of institutions, certainly not at SCOTUS, at the United States Supreme Court, although of course I'm open to that. But I'm just putting it out there as kind of an institutional idea. Again, it comes, maybe Liz is more uncomfortable than I am to kind of lean on the reformist thing. And here I want to say something else about the unique US situation. I think I'm more amenable to this because I live in a system that I feel is really in a crisis. Not necessarily, I mean, the administrative state, I don't know what's going to happen, but there's a lot of uneasiness and tension in the field. And my sense is that we talked about it before we formally started this webinar or the talk, very polarized, very highly polarized views. And I do want to try and get Americans to see that other systems maybe are lacking these conditions, to kind of have a legal regime that might be more constructive to kind of and facilitates the discussion rather than make a sense that, you know, the law lands on only one side when the other side kind of loses dramatically. So this is just to explain why maybe my own particular conditions and situations make me more amenable than you might be to lean on the reformist elements of comparative law and comparative administrative law.
Okay, thank you, Oren, for this last comment. I want to ask my comment, but it's maybe getting us a different place, and I'm sorry for that. But my comment is more about this kind of incrementalism that you mentioned, and the next little step that can be done. And you seem to suggest little bits and pieces from the administrative law machinery, some specific principles of doctrines. And I can see that I'm not questioning that approach, but I wanted to suggest maybe something different and wanted to hear what you think about it. Is that administrative law can be very general, or it's supposed to be ideas, doctrines that apply in a range of different sectors or policy areas. And I'm wondering if one incremental step might not be to take specific policy areas and to look at what can be done in these policy areas. I don't know, in energy sector, public procurement, or you mentioned welfare benefits. And would it be possible to look at these little bigger policy areas to see if your approach would work in some ways? And then, because you can replicate that across a number of areas, you can expand that at a more general level. Would it be some kind of incrementalism that you would embrace, or do you see difficulties and challenges with that approach, or it's not something that you would like to go for?
Right. So another way that one can point to a weakness in the presentation, and again, I'm putting it out there as a weakness, is that it focuses on what we can think about as the trans-substantive level of administrative law, the APA level, kind of the grand administrative law. And when you look in a more bespoke way on different domains, you actually see more engagement, I think, even in US administrative law. Obviously, I mean, environmentalists, they would be aware of important international treaties or what other systems are doing. They are less parochial in the sense that I'm attacking. And that's important. By the way, my next paper, I hope to finish it, is about the need to think about administrative law in a less trans-substantive way. And I think that Liz actually has a paper on this, or I've read something, I don't know if, or a theme in your work, I don't know, maybe that I'm using. I can't remember exactly why, because partly I'm on a roadshow with this, our parochial administrative law paper. But it is an item that I'm thinking about. I think, again, that the US is suffering from an excessive amount of trans-substantive administrative law. So all this is to acknowledge some kind of weakness in the presentation. Still, I want to suggest that it wouldn't be enough to just look at the domain. I think that the trans-substantive level is really important in US federal administrative law. We talk about Chevron, for example, as a kind of trans-substantive way. We have the APA that has become, for better or worse, really central for the self-understanding of US administrative law. So if we want to have big change, or again, change, I'm immediately falling to the reformist trap, better expertise, better understanding, the kinds of benefits that we all agree exist in comparative law, we have to be also trans-substantive, certainly in the US.
Okay. Thank you very much for that point.
I could come in, but I don't want to hog.
Do go.
Okay, so it was very interesting. So I think where we're probably actually disagreeing, Oren, is that I'm not saying. I mean, in a sense, I think this is a slower process.
Right. No. Right. I agree.
So that's the first, and I think again coming back to this idea of imagine better. I think it's just understanding that things are completely sort of imagined differently in different places. So to give you an example, a judge, and I won't name the jurisdiction, who's, he said, I just look at Chevron and it's just like an old time religion. I just don't get why they're all really upset about it. So it's not even, it's just like, why, is the kind of response. And I think sometimes people saying why. On this relationship between the horizontal and specific, of course, this has been a really interesting debate within the UK and the Commonwealth. And I was smiling because a paper that I've just been working on with two colleagues here is to argue that, so there's this argument, are there general principles of review or is it just specific areas? And there are 2 points I'd say. One is in this paper, we argue that it's not bespoke. Bespoke is very individualized. It's actually tailored. You're taking the same template and you're tailoring it to specific contexts.
It's a useful term.
It's a paper with Savile Row suits. It was inspired by one of my colleagues watching Project Runway. Important cultural kind of stuff in there. But the second point is a project I'm working on at the moment, which is looking at the last 50 years in Australia, the US and the UK, is looking how environmental problems actually shaped mainstream administrative doctrine. And Chevron is one of among many examples of that. So I think, but again, what I would say, this is my in praise of parochialism. Seeing that came from actually seeing that administrative law, it's not about higher law. It's not about international law. It's about understanding what goes on in specific places. I mean, it's this really interesting, the more comparative I've got, the more parochial I've got.
Right. So just to push back, I fully agree, but just to complicate this because we're academics. So I agree with it's going to be a slower process, but, I also feel like, history is changed by brave people doing things kind of well and powerfully, and then people follow on. So I think that as if I get more people to be smart people to do powerful comparative work that has real kind of, benefits and payoffs, we will speed up the process. So just a small pushback against just taking it slow. And on the I believe, again, I said I have a paper on the benefits of less trans-substantive administrative law. In the US, it's really interesting. We describe the APA as a mini constitution. I don't think it's a healthy way necessarily to understand the field of administrative law, but I don't want to go totally bottom up or totally there, because I think it's important to also build theory, even meta theory, to supply larger constructs to understand, even if they're kind of, concepts rather than conceptions. So I want to get the balance right, that I agree might be more localized or kind of less trans-substantive, but I don't want to disparage the people who can build the constructs and do the general work to do it well.
That's pretty challenging, what you are putting us forward. I mean, to balance the local and the more conceptual, that's a kind of a very broad spectrum. So you need patience, I think, to build all the little steps and linkages. I mean, but I can see the point you are trying to make. I think I can try to see the point you are making about about also the importance of conceptualization and theories. I mean, in terms of having a sense of what we are looking for. And I think somebody mentioned that earlier today, and that it's kind of a reiterative or recursive approach. We need the local to feed our imagination. We need the concept to see what kind of imagination we can bring to at the local level. So it's kind of, the experimentalist approach to things, I suppose, that you are applying here. And
yeah, I remember, by the way, just to say, there's a series of papers from the 80s that were interesting debates between, I think, Carol Harlow, Peter Kane, Paul Craig, about the kind of virtues of conceptualization versus, lacking any theory in administrative law. So I always thought it's kind of a false dichotomy. So that's my view, but I think it's a paper's worth kind of going back to.
Okay, so
can I just, but there's a danger that thinking that engaging in the local is not conceptualizing. There is a danger in thinking. I mean, it comes back to, it's where we, to use a distinction of Ursula Le Guin's between imagination and wishful thinking. Wishful thinking is detached from reality. Imagination is grounded in reality.
Right. No. I think.
I mean, again, I don't think we're necessarily disagreeing, except I've never found much analytically useful in getting too general in administrative law.
I don't know. We probably don't disagree, but I also think it's a matter of scholarly talents. Again, I don't know what my talent is. I might not have a talent, but I think there are people who are more kind of are able to work productively on an abstract level, and there are people who are able to kind of conceptually build again and theorize. It's a question of tendency and scholarly ability, and I believe that there are those people that are able to offer larger constructs, not through grounded work necessarily.
Okay, thank you so much for this discussion. So I have the impression that we can dig and go on and on this kind of tension, but it's fascinating to see approaching it from different angles, so shedding new light or maybe generating ideas for everybody on the panel today. So I think it's time, or we are close to the time. So I don't know if somebody has a last word. Maybe, I don't know, Liz or Mariolina or Ren, do you want to have just one last word, or is it okay?
I think Mariolina's been very quiet, so she should have the last word.
No, I do want to leave. I do want to finish on time, and I want to leave a couple of minutes for Isul to have the couple of final announcements, I think, but I think there is plenty of food for thought in this presentation, and very interestingly, Oren, I think the points you raised, especially the methodological ones, are valid and are worth discussing further, both for the US and the EU scholarship. So my point is that it's not because we have a longer or deeper tradition of comparative administrative law that we're kind of done discussing it and how to do it properly. So I think that's really, your paper is really a step in, nurturing, let's say, a debate that is useful for all of us. So thank you once more.
Yes, thank you very much.
Thank you so much.
Let's thank all the colleagues from Mariolina, Liz, and Oren for the discussions. It has been really fascinating and enriching, at least for me, and I'm sure for everybody on the call. So I would like also to thank Chantal and Danai for the logistic help today. That was very helpful, so thank you very much. We hope very much at VLO to welcome more of these discussions in the future, and we have a new event to ask you to put in your agenda if you are interested. It will be a third dialogue for Tuesday, the 23rd January 2024, with Professor Jacinta de la Cananea, Professor Dimas, and two practitioners, one from the EDPS and one from the Belgian Competition Authority, and they will discuss procedural requirements in theory and in practice. So if we will circulate an announcement, and you will be able to register in the very next few days. So we hope to see many of you at that event. And you will be able to find the recording on the blog in the next few days as well. So thank you so much for your time, Oren, Mariolina, Professor Fisher. That was really very valuable. Thank you very much.
Thank you so much. It was really a pleasure, and I hope we'll stay in touch.
Bye.
Thank you.
Thank you. Thank you, everyone.